Welcome to the Law Matters. Of course it does. Hi, I'm Debbie Moraes, your host and moderator. This program's been created to educate, inform, and help you with law matters because the law matters. Understand the law better, and you're in a better position to decide how to protect yourself, your family, and your business. We provide information and resources that will help you decide whether or not you need or want to contact a lawyer. Perhaps will help you determine that you can actually handle some issues yourself. If you do need professional counsel, you'll be better prepared, and as a result, so will the professional you select. Our goal, of course, is for you to achieve best results, save time, and save money along the way. The Bazar and Associates law firm in East Providence continue to donate their experience, their time, and their insights on the various topics that we tackle. So we once again want to welcome and thank Attorney David Bazar.
Thank you.
So today, David, are we ready? Today, child custody and the new challenges facing families and the court systems nationwide. We'll talk about some very recent landmark stories, but the expanding definition and of what it means to be a parent, it's complicated. We'll talk about that. What hasn't changed and seems pretty clear, the welfare of the child is of paramount importance in any decision. That seems pretty simple and straightforward. How that plays out in the courts these days is anything but. So we're going to cover the basics and then get into some of the complexities of non-biological, non-adoptive partners seeking custody and visitation rights. Also, what happens when there is abuse, when there's domestic violence, abuse of children, alcohol, mental health issues, a host of things to deal with. So, David, let's first get into the situation of what is custody and visitation? How is that handled?
So traditionally, in a divorce, where there are children, one of the very first issues the court has to determine is who's going to have custody and what schedule of visitation there's going to be. So starting with custody, when I first started practicing, it usually was sole custody with the mom. The dad would have a visitation schedule. And as it developed, there was a lot of pushback on that because if dad didn't have joint custody and something happened to the child while the child was with him, could he bring the child to the emergency room? Could he sign for medical procedures? What was his authority to do to make sure the child was cared for? And why shouldn't the father in those instances have a right to talk to the teachers and the doctors and input into the decisions being made for the child? So it's evolved to the point where most awards of custody are joint custody, which is a legal fiction in the sense that you don't share physical custody of them, but you both have the joint responsibility and right to make decisions for the children.
And I think from the standpoint that you started this was earlier on when it was almost a foregone conclusion that unless something very peculiar happened, mom usually had at least the custody initially, and then you said something about could the dad then go to the hospital, sign the PTA forms or whatever.
Right. So when we first began, there were doctrines in the law that were presumptions that the mom was the parent who should have custody. They had a doctrine called the tender years doctrine, which was a young child needs to be with his or her mom. And so all of these factors were sort of geared towards or slanted in favor of mom having custody. And as I said early on when I started to practice, that's the way most of the judges looked at it. So then as we developed and we started having more and more joint custody cases, the factors that would go into that changed. And of course, I think you mentioned at the beginning, the overriding factor is what's in the best interest of the child. And then there's a number of other things that go into determining what's in the best interest of the child.
I think we should get into that, but before we do, describe, I know that there is a joint custody, elaborate on that a little bit versus sole custody. How does that actually play out for most people, and is that state to state, nationwide? How does it work in various situations?
Family law is generally state to state, but some of these types of considerations and issues do cross state lines. In other words, they're applied similarly in different states. But each state has its own laws on divorce and custody and child support, although there's some nationwide federal regulations that can apply to child support. But by and large, it's a state law that you're looking at. So when you look at the state law and the development of it, as we talked about, sole custody was where the mom had the physical possession and the rights to make all the decision, and dad would visit. Then joint custody, the physical possession was probably the same in the sense that if the child was with mom, she had actual physical custody, and dad would have visitation, but he would have the legal rights to be involved in the decision making for the child. And then also what developed as after that was shared custody, which is a little bit different. Now you are talking about a shared placement situation. And I remember a case that I had many, many years ago, early on in my career, with a judge that was sort of at the end of his career, who had come up with the tender years doctrine and was brought kicking and screaming into the joint custody world. And now I'm introducing this idea of shared custody with him. And in fact, my client was the wife, the husband was represented by someone else, but they were very progressive in their thinking at the time. And they had a notion that they would keep the house, and 1 month the mom would live in the house with the children, and the children would visit the dad at an apartment, and the next month the dad would live in the house with the children and the mom would live in the apartment. And I knew that that would work fine because of the way they were, up until the point that either one of them had another significant relationship in their lives, and that might bring some pressure to bear. It would bring a wrinkle that might not be easy to work out. But the long and short is the judge just couldn't wrap his mind around going into something like this, some cockamamie arrangement like that. But we eventually convinced him that that was in the children's best interest. It's what the parties wanted. They had thought long and hard about it. And the best thing that can happen for children who are going through a divorce in their world is to have two parents who are willing to work together to do what's best for them.
And of course, you're talking about what at the time was progressive thinking and a bit of a wrinkle. And now, before we even get into some of these more awkward choices and issues that are presented, how about even when one of the parents needs to move away from work, and then you have another, either an opening of the custody battle again or revisitation, and those things are still pretty easily worked out through courts and lawyers?
Well, if you're going through courts and lawyers, usually nothing's easy.
We'll get into that too.
Hopefully the parents can try to work these things out. And I've had cases, some of what you seem to be just hinting at a little bit is relocation cases where mom or dad's job moved and they have to move out of state, and how do you deal with those things? And again, there's case law that you're looking at, and it really goes back to the same theory, what's in the best interest of the child, and a lot of the same factors go into that. There are some different factors on a relocation. For instance, where's the child's family and the roots, and the friends and all of those things may come into play as to whether a child should move out of state or not be in state. Those types of things, but it's the same overall overarching issue as to what's in that child's best interest. That's what the court's supposed to consider among all of those factors in reaching that decision.
And would you say in these fairly typical cases, as we're discussing basics of custody issues, lawyers, mediators could be maybe a little less expensive for someone if they can work together amicably and iron out situations?
Mediation is a really good process for working out custody, visitation, any of the other issues surrounding children, because the goal of mediation is to get the parties to start talking to each other and sort of work it out themselves. The idea is, as a mediator, what I would try to do is ask, if we have a mom and a dad situation, Mom, what do you think? And then make sure dad listens to what mom says, and then dad, what do you think? And make sure mom listens to what dad says. I remember having one where mom wanted dad to visit, among other times, on Wednesdays, take the children for dinner and then bring the child back or children back for school the next day with the moms to sleep. And he wanted to visit on Thursdays. And I'm going back and forth with them, and finally it came out, well, he had an obligation on Wednesday. He couldn't do Wednesday. That's why he wanted Thursday, but it never had just gotten discussed and brought out. And when she heard that, she said, oh, I didn't realize that was Wednesday. I thought that was Tuesday. They started listening to each other, and they were able to work out what they needed to work out. And actually, it turns out Tuesday was better than Wednesday and
or
Thursday for both of them. But they never really just started opening up and talking and being honest with each other about what the issues are and why. And once they did and they started listening to each other, they were able to work it out. That's the goal of mediation. That's why mediation, if it can be done well and done right, and then opens up the lines of communication for other issues down the road, is a much better way to get these things resolved than having a trial in front of a judge who's going to have to make the decision for the parents, whether one or both or none of them like it, you never know. But the whole idea is that if they can make their own decisions, it's better than having what I would call a stranger to the situation, a judge who's being paid to make the decision, and he or she will make that decision, but it's their decision, not your decision.
Good to bring up. Is it difficult for judges, or I guess it's media, but really a judge, to decide on the factors that would determine whether mom should have custody, dad shared, however they do that? Two moms, two dads?
I think it's one of the most difficult decisions a judge would have to make, which is determining between two equally good parents which one should have custody if the parents can't agree on that. The factors that they look at are important, and there's one in particular. If you have otherwise really equal parents, is which parent, this is my factor if I were the judge, which parent would be the one to most encourage the relationship of the child or children with the other parent? Because now you know that that's the parent that is really putting the child's interest first. And if you can make a determination after listening to the parties and viewing their demeanors and what they have to say and what they don't have to say, and reading between the lines of different questions that might be asked, that the father or the mother is really going to be the one to encourage that relationship with the other parent, then that's the parent that I would choose for custody.
Sounds wise. So this is probably a good time to springboard to what if the child has two mommies, two daddies? Does a gay parent how does the gay parent situation weigh out in the courts right now? It's not mom versus dad, it's mom versus mom, dad versus dad, or whatever.
I would argue that the same rules that apply to a heterosexual divorce situation, a mom and a dad, should apply to a single-sex situation. It's the same factors of what's the best interest of the child. What you see happening in some states, and that can happen, is there might be a biological parent versus a non-biological parent, and they try to use that card as a trump card in making these decisions. But there's a case in Rhode Island that I know of, I think it's called Parenthood versus Parenthood, which talks about a putative parent situation. And what that one was, if I recall correctly, is a mom and a dad raise a child for many, many, many years, and then when the case comes up for divorce and allegations raised by the mom that the dad's really not the parent of the child, and DNA testing, I believe, was done, and the dad was not the parent of the child, but the court held it because the dad wanted to be the dad, and he had raised that child from the beginning. So the court held that he has all the rights of a father, he's the putative father of the child, and we're not going to take away those rights that were gained over years and years of raising a child because it's all of a sudden sprung that you're actually not the dad. So he was given the rights that he should have been given as the father. So if you have two moms or two dads and they're raising a child and one of them, they get divorced and one of them is not the actual biological parent, I would argue that that parent can rely on the case that says if you've raised that child as your own for all those years, you're the putative father or mother, and those rights can't be taken away from you.
Would you happen to remember, David, in that situation, did the actual biological father ever claim rights or want visitation?
Never part of the picture.
Never part of the picture. What would happen if that biological father now enters the picture because he's just learned that has some rights, I guess? Does he? How does that work out in a custody case?
We need more facts.
Okay, I was trying to
okay, so we need, are
we
dealing with a married couple who has a child and now the biological father's coming into the picture, who never known to anybody, the father of the child from the marriage has always thought he was the father, and what rights, if any, does this person who's now coming in to a marital situation have in terms of visiting a child that he never knew was his?
Does that happen?
Well, it can happen.
And?
It could happen. So there's a presumption in the law that a child that's born during a marriage is a child of the marriage. And it's a rebuttable presumption, but that's the presumption that's given. And now if somebody comes in all of a sudden, and I would argue it depends how far out it is. But if we're talking a child who's now 17 and going to be 18 years old, and he wants to assert that he's got a relationship, when that child's 18 years old, that child's an adult, that child can make a determination for him or herself whether they want to have a relationship with this person who they've never met or known or whatever. It's not dissimilar to an adoptive situation. And so I would maintain that within the marriage, without a divorce or anything else coming into play, that that child is a child of that marriage. And if someone comes from outside, just like if it was an adoption of the child by both parties, the biological parents and the child, the rights are very limited once there's an adoption, because legally in the adoption situation, that parent is that parent. And I would argue if mom and dad both thought, or especially dad, that that child was his child and he's raised that child for 15 years or 13 years or whatever number of years it is, and someone's now coming out of the woodwork and say, wait, I really think that's my child, that there's going to be a presumption that, no, this is the child, just like the putative father situation in the divorce. And I don't know that the court would allow someone to move their way in that situation.
Okay. And in one more fairly typical case these days, as families have become blended and expanded, a mother and father divorce, mother keeps the child, she remarries, there's a new husband on the scene, the husband wants to adopt that child, he does. So there's an adoptive father on site with the biological mother. If that relationship dissolves in divorce, is there ever a chance that the adoptive father, under normal circumstances, is there ever a chance that that adoptive father has an opportunity to say, I'm likely to have, or I should have, either sole or at least very shared joint custody? Possible or not?
Sure. The adoptive father steps into the shoes of the biological father. He is the father for legal purposes. So if you have a child, you've adopted the child, and there's a divorce, you have every right to ask for custody, child support, visitation, whatever it is that is appropriate under the circumstances.
Okay, so let's get into some of the challenging ones. Most interestingly, about a week ago, New York's highest court expands definition of parenthood. Okay, there is an expanded definition of parenthood these days, but they're talking about a caretaker who's not related to or the adoptive guardian of a child could still be permitted to ask for custody and visitation rights. So the long and short of it is that there are two women who are together. One is the biological mother. The other, obviously, it's not a father, but they've never married. However, that mother ends up saying when she separates from her partner, she wants that the other mother to have not only no custody, no visitation rights. So when they sue for custody, first thing, the other one was denied. Now on appeal, they say it's absolutely true. There are increasingly varied familial relationships. And now here's a story where the courts are saying that other mother is absolutely entitled to be having custody and visitation, doesn't need supervised visitation. Comment on that? It's really changing. It's a landmark decision to have that happen.
Right.
What do you think about how that's playing out? And it won't just be in New York, of course.
So let's just think about it in terms of a traditional relationship. So if there's a mom who has a child.
With her partner.
Yeah, but
at the time.
So I'm just going to say a man and a woman, just
Okay.
to change the facts a little bit. Man and a woman, they have a child, not together, it's the mom's child, but he raises that child with her, even though they've never been married. What that case is saying is that he should have rights to visit that child. And I've had cases like that. And the judges have been resistant to that notion. Either you're the dad or you're in a relationship where you have rights that can be created, such as that putative dad who was raising a child as if it was his or her own. And as a parent, his or her own, and therefore develop these rights. Now they're saying if you're in a relationship, not a marriage, but just a relationship, and you raise the child, you should have the ability to visit the child. And so I had a case recently where that was the argument we made. And they were never married. My client raised both his son that he had with the mom and her daughter from a prior relationship. And the first time through the court said, well, you know what, she should visit, the sister should go with the brother on visitations. So they didn't give an order that he could have visitation with the sister directly, his daughter, but rather that the sister should accompany the brother on the visitation. It was sort of the judge's end run on making a decision directly on that. And then she's a little bit older, we're back in court, and the new judge said, I don't know that you can do that. And I'm saying, well, yeah, you can. There's a putative, statute, for our case on the marriage situation. And I said you should really look at the same factors. What's in the best interest of the child? If the child has had a relationship with this person for all these years, and because the relationship with the mom or the dad has ended, why should the relationship with the child end if it's in the child's best interest to maintain that relationship? And especially in the case that I had, where there was a child of the marriage who was going to still have a relationship with the father.
Yes, yes. So in this case, where these two women were together, yes, one was artificially inseminated, but the other one was there on scene, and I believe some of the details included that the other mother, cut the umbilical cord, had the baby take that other woman's name. She was there, she raised them, and they were together for probably 3 or 4 years. She served as the on-site caretaking parent, not adoption. There was not an adoption. But now when they're these two women and their relationships had been broken up, it makes perfect sense in the logic that you're using, that what's in the best interest of this child. This child absolutely has been with that other mom too for that many years. Precedent setting.
The reason I wanted to use the traditional setting as a sort of hypothetical to give it is, to me, the same reasoning would go into the case whether it's a same-sex couple or a heterosexual type situation, man and woman couple. It doesn't matter. It's the same reasoning. It's the same idea that it's a family. And if the family is two moms, the same reasoning should go into what is the best interest of the child in determining whether or not the other mom should have custody or visitation or both. And it's interesting because the only quirk to me isn't that it's a man and a woman or two women or two men. It's whether or not the marriage relationship should be in place to make that determination. And once the court starts saying that, no, you can have parental rights whether you're married or not, and you can develop these putative parental rights in a non-marriage situation, then it should apply equally to both sets of couples, all sets of couples.
So it looks like, whether it's just New York here, that this is certainly likely to expand, and they're taking into consideration now the idea of what a diverse family looks like, and it looks very diverse. And
right.
Whether there was the marriage, non-marriage, still a committed relationship, and then there's another situation of not actually even being legally adopted by this other woman, but still she was on site and so involved.
I'm not sure if in most states you can adopt a child to two people who aren't married. So I don't know that she could have adopted the child.
Another complication or wrinkle.
Yeah, if they had gotten married, then they could have proceeded with an adoption. Then all the legal rights would have applied just like a child born of the marriage, and there wouldn't have been an issue with that.
And you bring up a good point. At the time when this situation took place, gay marriage was not allowed. Okay. And then as they went on, they just didn't get married, although by these years it would be something that could happen. They didn't retroactively do. Right. So now it just changed the nature of that situation, but going forward, very likely you would have marriages rather than
well,
not.
Actually,
or not.
You know what would have been a very interesting situation is if it was in Rhode Island, where there's common law marriage, and they had the relationship before you could have same-sex marriage, before the Marriage Equality Act, and so they're living together before that's passed. So there's an impediment to their being married because Rhode Island didn't recognize it at that time. Now the impediment to the marriage is removed. They're still living together, and if they're acting as spouses, as if they're married, then I would wonder, and I've always wondered what, I would like to have that case to find out what it would be, because I think it should be, is if a man and a woman living together could have a common law marriage, why couldn't two women living together have a common law marriage? And so if I was representing that woman who was the non-biological parent of the child in Rhode Island, one of the things I might think about alleging is a common law marriage if they believed themselves to be married without a ceremony and held themselves out to be married and had the present intent to be married. Then in Rhode Island we could make that argument that they were married, which certainly would have changed that whole need to create some landmark ruling about whether or not there was rights to visitation and all of that anyway.
And especially since the child took the name of the non-biological mom, too. Interesting. So comment, if you would, on these other wrinkles, should I say? Not a great choice of word these days, but some when there's a divorce and a custody situation, when you have one parent with a mental illness, or you have a drug abuse situation, or some domestic abuse. I understand the importance of taking care of the child. How does that factor in, and how does that play out in the court systems with custody cases, David?
Well, it's one of the factors that is in the statute, as you look at when I say one of the factors. The ability to care for the child is one of the factors. And if somebody is an abuser, there's actually, right in the statute, a language about someone who has domestically abused the partner. That's grounds for custody to be given to the other person. So those are parts of the factors that go into determining the best interest of the child.
And if there is a drug situation, would they automatically cut one way or the other, or just say you could be joint as long as one of those, the person who has an addiction problem is seeking counseling or whatever? How does that play out?
So again, there's a couple of different issues. So certainly someone who has an addiction problem and has trouble taking care of themselves may not be able to take care of a child, so custody is probably going to go to the other parent. The question is, what are they doing to take care of themselves? So that, does visitation need to be supervised, or are they able to at least visit without supervision? And frankly, most of the judges today, if someone is actively using drugs and has a drug problem or a substance abuse problem, they're not going to allow unsupervised visitation.
Good to know. Good to know. We hope that this has been helpful to you. We've certainly covered quite a few of the common topics regarding custody, but certainly the complications as laws will probably be changing. So stay tuned to the Law Matters, because the law matters to you.